the vast majority of employment contract I've drafted, there's a specific clause that says anything that you invent in the course and scope of your employment belongs to the company.
This is my question. We have it in Botswana where we're told, I don't really want to say the regulator's name, but they're saying, come and do it. You can do it here. And, you know, these things then come up later on where you now need a lawyer to come and help you out and solve these problems. But that's saying you can come and do it. You can come and trademark your things. You can come and do these things. I want your thoughts on that.
Just balance it out for me. How do we work it out between the interests of the corporates and, of course, the idea generator?
One thing that piqued my interest, they were speaking about the 46 million. And in that moment, I questioned myself as to how does one value intellectual property, because as per my...
Hey everybody, welcome to Deep Dive Sessions. My name is Mphomo Taro. Our goal with this show is to bring you and I in proximity to the people and ideas that will show us that it is possible and it can be done and eventually help us achieve on our dreams and on our goals. Today we have a special session. This is our first Deep Dive Super Session where we'll be dissecting the Please Call Me case, Makate VS Vodacom. We're going to be talking everything IP. So ladies and gentlemen, to facilitate this conversation, I'm here with a special guest, Mr. Topiwa Chilume. Yes, sir. How are you doing?
I'm good, yourself?
Lovely, lovely. I'm so excited we're having this. Our topic is intellectual property. Everything we need to know about intellectual property. So let's start first by talking about the case, Makate VS Vodacom. Just a small synopsis. I'll give a bit of what I know and then you can add on to that. So Mr. Nkosana Makate, South African, came up with an idea, Please Call Me, back in 2001. Essentially, when he started this, he was having a long distance relationship with his then girlfriend, who is now his wife. And they were having problems with, reaching each other. So he developed Please Call Me. And this was something that was taken by the Vodacom, by Vodacom. He actually took this idea, he pitched it to the product manager and the director of Vodacom at that time. And he told them, this is the idea I've come up with. And then they were like, okay, let's try this out and see if it works. And so they tried it out. It became a whooping success. Vodacom has generated billions from that. But Makate has not gotten anything from that. So Makate went to them and it's like, I generated this idea. This was my IP. This was mine. I invented this. And Vodacom were like, you're working under us. So it's ours, But Makate begged to differ. And so he went on and on with it until he left Vodacom and started, he actually went to court with it. I believe this was 2008 when he went to court with it. But you can take it from there.
Yeah, I think you've taken all of my words, but basically, I think what I would like to highlight is that the hook, if I can call it that,
yes, was
that it was actually pitched towards children and family, because we get please call me many times, and we ignore them if you know who it's from, but it was meant for children. And obviously your wife. And these are people that you have to call back. Rather than, having somebody without airtime.
Yes.
What can I add? Makate was also an accountant.
Yes.
Just so that I can give you a bit of perspective. He was an accountant. He wasn't even in the research and development part of Vodacom. So he literally just went to them and said, and this is where, and we'll discuss it further, this is where the contract came into being. He said, yes, I've got this idea, but I'm just a mere accountant. Consider it, look at the business case, and then in return, I want a percentage of the revenue generated by just that line. I'm not 100% sure of the figures from the time he pitched it to Vodacom up to now, because the price, the amount they have to pay Makate hasn't been determined yet, as far as we know. But we are looking at between 47 and 57 billion. I'm highlighting that because that's the value of IP. So we have to take it seriously. Even if he gets, I mean, you can just imagine the scale. Even if he gets 5%, that's some nice retirement plan for him and his family.
Definitely.
Yeah.
Yeah. So, did Makate's employment at Vodacom impact his intellectual property regarding the concept he developed during his time there? I think that's what I...
The main, because I'm going to play on both sides, on the side of the employees and on the side of the employer.
Yes.
The vast majority of employment contracts I've drafted, there's a specific clause that says anything that you invent in the course and scope of your employment belongs to the company. So my view is that Vodacom was and possibly still is negotiating from that perspective. Even if it's not in the contract, the mentality is that you invented this, you were probably using my laptop, my electricity, my water, you were in my offices, therefore everything belongs to me. I think that speaks to the reluctance of Vodacom to pay him his fair share.
Yeah. So I was just thinking to myself, I'm like, Vodacom probably changed the entire employment clauses after this whole case, just to make sure they don't suffer something like this again, But how important is it to document and formalize all these agreements, especially where IP is concerned? These, every time you take it out to somebody, or every time you're saying, this is what I have, how important is it to formalize and write these down and do it the right way?
I think at that stage, the most important document, having checked your employment contract, that's the obvious thing. Because then if that clause is watertight, you have to find ways of, how can I put it, inventing it elsewhere. Maybe work from home or something like that. But that's the first step. But secondly, you have to sign a non-disclosure agreement before you share anything with anyone. We often overlook that. Generally, non-disclosure agreements...
So this is employees signing NDAs with their employers?
If you do have an idea,
okay,
or some whatever business plan,
okay,
which also covered under IP, by the way, you sign an NDA. The NDA itself, how would I put it? It establishes the contractual basis on which you can sue somebody. Because remember, at that instance, you haven't registered anything. So you need that contractual basis to be able to sue the other party, in this case, your employer, to say you signed this agreement on such and such a day. Part of the agreement was that you should keep my IP confidential. And the most important aspect, using this Vodacom case study, is what we call a non-circumvention clause.
Yes.
That basically, and it's hidden somewhere, some NDAs have it, some don't have it, some don't understand why the clause is there, and they wouldn't pick it up if the clause wasn't there. But basically it serves two purposes, depending obviously on how it's worded. The first thing, it maintains the confidentiality of your idea. Non-circumvention basically means no one can bypass you. And that protects your your commercial right to your IP.
Okay.
In other words, had what's his name again?
Makate.
Had Makate signed NDA with Vodacom, that clause would have read that you keep it confidential. Secondly, you can't approach third parties without my approval
Consent, yeah.
or whatever.
Okay. So what factors determine whether an idea or a concept can be, can have intellectual property? Like what factors determine or can be considered in terms of, is this something that is intellectual property? I don't know if you understand my question.
Yeah.
Yeah.
The general, I would say, definition is IP is a creation of your own mind, from your mind, through mental labor or activity. So virtually anything that you come up with, which is new. Novelty is a big word in IP.
Right.
So it has to be new, which is new. You haven't copied it from anyone. Falls broadly into that definition.
Okay.
So it could be anything. The second point is, well, it's really more of a distinction I can draw, is that there's IP that can be registered in terms of our present legislation. In other words, the laws we have now. And then there's one, again, I'll refer to the case study.
Makate.
Makate.
Yeah.
I don't know why I keep repeating the name.
Yeah.
In the Makate's case, it was essentially a business idea. I don't even think it was at the stage of a business plan. I think he just said, listen, this idea is brilliant. Send a free SMS, then somebody calls you back. And then he gave it to Vodacom, for Vodacom to develop the financial aspect, the software to back up that idea. So they did most of the work. He, I assume, just had a brilliant idea. Maybe he had a dream. I wish my wife could call me now.
Yeah.
But
Yeah.
she doesn't have airtime type of thing.
Right. So in terms of registering those, can we register ideas in Botswana?
No, you can't. I got sidetracked.
Yes.
I was going to touch on that distinction between IP that is capable of being registered
Yes.
and IP that is not capable of being registered. In this case, a business idea can be registered. Our laws have patent, copyright, and trademarks. I mean, there are others as well, such as designs and so on. But things like business ideas, your customer lists, your databases, they can be registered, which is why the emphasis, certainly my emphasis, is to try and protect your IP commercially through these NDAs, through these license agreements, through these royalty agreements, through assignment. Assignment is if you just sell it outright.
Okay.
For instance, Makate could have told Vodacom, listen, give me 25 million. And he was wise not to do it in this instance. Give me 25 million and I'm gone.
Okay. Looking at the case, what role did the initial agreement between Makate and Vodacom play in establishing intellectual property rights? Because I want us to understand how this became an IP thing, so that it grew into what it is today.
Well, the minute he thought of the idea, it became his own creation, provided that it was something new in the market.
Yes.
At the time. That's the first thing. When he unfortunately chose to do an oral agreement with whoever he was speaking to.
Yeah.
But fortunately for him, oral agreements are as enforceable as written agreements.
Are those who binding the side?
Yeah.
Okay.
It's a general principle of our laws. A written agreement, though, gives you,
Yeah.
it avoids the he said, she said, back and forth. So it's always wise to have a written agreement. But to answer your question, the minute he pitched this idea to his employer, his IP rights became entrenched.
Okay.
Yeah.
So if I'm an employee right now, say I'm working for this company and I want to help it advance. I'm also working in product development, maybe like Makate was working, and I want to be able to assist in certain things. Any idea that I put forth, I have to follow these channels that we are talking about.
I mean, first of all, you look at your employment contract.
Yeah.
To see if you can invent things and benefit off them at your place of employment. But then, obviously, the next step, once you can, then the next step is the NDA. If you don't want, if you're not, what's the word? Sentimental over your idea. Like I said, you can just sell it outright. Yeah.
Okay. Well, that's interesting. Because I'm asking this question because now it becomes, and now, like you're saying, at least you answered it in the sense of you have to go and look at your employment contract and ascertain that that's the case. So if that's not the case, that allows you that means they own anything that you give, essentially.
Yeah, I mean, again, given that...
Like anything you develop, they own it.
Yeah, given that decision came out of the Constitutional Court, which is the highest court in South Africa. So a lot of these clauses will be looked at now, because the judges specifically say it sets a new precedent with respect to compensating fairly people for their own innovations and ideas, even in the workplace.
Yeah.
So you might find that these clauses, were you to go to court, they might look at them in a different way. Yeah, but previously, if the particular clause didn't provide for that, then your idea goes to the company, to your employer.
So as an employer, then you have to state these to all your employees, essentially, that if you give this is for the company. Because like at first we were talking about the employee. Now as an employer, you'd have to have those written down to ensure that that doesn't come and happen as the Vodacom.
Yeah, absolutely.
Okay. Now, if you when you look at this case entirely, as it grew, and Makate says there was a point where they wanted to pay him 47 million, and then he turned it down, and he said he didn't know where they took that number from. They had no line of sight in terms of how they developed that 47 million rent that they wanted to pay him. So if I know I have this idea or concept that I want to apply in my company, but I want to have IP ownership of it, how then what percentage do I think of it? Like what percentage is my idea? If it does do well, how much should I benefit from it, essentially?
Well, it's a commercial negotiation. I sort of implied earlier that he came with a mere idea.
Yes.
The employer came with the whole infrastructure, possibly the software as well, to push this product or service.
Yes.
Having said that, 47 million, it's too low a figure, in my view, because I think at a point in time during the case, he asked them to extract just the revenue generated by Please Call Me from one date to the other. Once you get to that 47 billion or thereabouts, I think it's fair to say, I think he had wanted 15%.
15%.
But it's definitely, I don't know if it's too high or not. I don't know what contribution he made, particularly on that product service, other than the idea. But certainly not less than 5%.
Not less than 5%.
Yeah.
Because it's also a thing of the idea was just the idea. Vodacom created everything around it. The infrastructure, everything. They created everything. So That's really where it stems from.
But then you see where oral contracts are a problem. Apparently, when they were discussing this, he says, here's an idea. I think it's brilliant. Give me a percentage of the revenue. Nobody knows. He said, she said.
Yes.
Nobody knows what percentage they had agreed on initially.
Yeah. I think there's also this also comes up. I think we've actually talked about this in academia, where I'm a student and I'm doing a research and my lecturer is with me, and then the lecturer is also employed by the school. Is it mine? Is it the lecturers? Is it the schools? How then are we able to dissect it? How then are we able to make sure? Because if I can do something and it's groundbreaking, and it changes lives, how then are we able to set it up right from the beginning?
I mean, again, one, you can register it. If it's not capable of being registered, then you need to come up with, NDAs, whether you want to license it, whether you want to sell it outright, whether you want to co-own it. So there are a lot of commercial ways and agreements to cater for that. But it's difficult in a research institution. It is difficult because the way thing. Four-way if you add government.
Yeah.
Because they own the institution. But it's essentially three ways. The inventor, let's say, is the student, but he or she is using the lab owned by the institution. He's probably also helped by the supervisor or lecturer. The institution also feels, because you are working in my lab, I deserve a cut of anything that comes out of it. So it needs to be very carefully managed, I feel.
It's very...
It currently isn't managed to that degree. I'll put it to be politically correct.
It's currently not managed, I agree. Yeah, but I think soon enough, actually, I think now we're actually seeing this happen a lot, and we should be very, very aware of this. So are you able to just enlighten us on actually some of the ways that IP is very prevalent in our time and day now, especially in your world where you've worked with many people in terms of IP, setting the IP right? What are some of the common mistakes or common errors that people make when they're supposed to do their IP properly?
Well, if you're in this area, you deal a lot with SMMEs, you deal a lot with startups, and the last thing they want to do is to pay a lawyer. But I would say from the onset that even if people can work on contingents. For instance, you pay them when you reach commercial viability, but you need to have a lawyer and an accountant around you from day one. But the problems that we see in the market is, again, people not signing the right agreements at the right time. And if you miss that non-disclosure agreement stage with that non-circumvention clause, then it's an inevitable slide downwards. The minute you share your idea with someone, or the minute you think of sharing your idea with someone, you need to have something in writing. To me, the other ones I'm not too worried about, but that one is the most important one. You miss that boat. And you need to be very careful. It's not only someone that you expect to benefit commercially with. Even when you approach the bank, before they give you money, they'll ask you to submit your business plan. Yes. Has anybody ever signed an NDA at a bank or CEDA? I know the precursor to CEDA. What was his name again? Maybe it was before your time. I think it was Bedia or something like that. There was some rumors about ideas being stolen. So again, this highlights the importance of an NDA. Don't share. I don't know if the bank will sign that NDA or your other investors, but don't share your IP. It's yours. If you do, have that NDA in place, properly drafted. And please don't download a template from the internet and change names.
Yeah.
I know we have, I'm sure you guys are aware of Chat GPT.
Yeah.
Please draft me an NDA. Don't do that.
Yeah.
Just go get proper advice. Even if it's on contingency because you still don't have money. I'd rather give my lawyer or my whoever is advising me a part of the shareholding so that my rights are protected from day one.
Yeah, so that it doesn't come back and eat us up.
Yeah, I've told you the value of Makate's share, the approximate value. So IP is big.
Yeah.
It can be big.
Yeah. No, most definitely. I'm glad you said that because the question was always going to be money or having these tools to use. Yeah, I'm glad you shared that. We're going to pause there for a break. We'll be back with Mr. Chilume.
Thank you again for this platform. Very insightful. My question is, one thing that piqued my interest, they were speaking about the 46 million. And in that moment, I questioned myself as to how does one value intellectual property? Because as per my understanding, it's something that hasn't reached the business stage as of yet. You might have an idea maybe on paper, it's just sketched out. So how does one reach that point with maybe a corporate company like my neighbor here has signed an NDA? How does one reach that point where they can say, okay, I'm going to decline this 46 million because I feel that my idea is maybe 1 billion?
Thank you for that question. I think it's more for the accountants as regards the valuation. But I think there's an accounting standard, IFRS 13, I think, that values goodwill. At this stage, in terms of accounting standards, we don't differentiate between goodwill and IP. So that's the stumbling block that you're going to face. Then the second aspect of my answer is that goodwill or IP is valued on disposal. So for so long as you have it, unless you've got a potential buyer, in essence, it has no value until there's a potential transaction.
I'd like to ask from the perspective of the corporates. I gather we've been giving a lot of attention to the other side of the equation. But when it comes to corporates, and given the aforementioned statements you've said regarding how they facilitate this innovation financially and or other, it seems to me that there's a balance of sorts that needs to be struck where an employer can still invest in their employees' activities and still find value in that. So from an IP perspective, in terms of, shall I call it fair trade, what should corporates be looking at? What should they be considering regarding intellectual property, generally from an international standards perspective? And then also, if we look at our environment here in Botswana, the level of maturity of IP, where are we in regards to that? Level of awareness, number one, you've touched on it. And number two, our corporates looking at IP as an area where perhaps they need to revisit how they are approaching it, and also looking at the potential. Like if you look at this case that you're discussing, the revenue that has been generated is substantial. So how can, as a business, look at how IP can actually contribute to the balance sheet of these corporates, as it were? So just balance it out for me. How do we work it out between the interests of the corporates and of course the idea generator, with specific reference to a circumstance where probably your job description involves coming up with novel ideas for the firm. You see now. So how do we strike that balance? Where do we? Of course, I'm asking for your opinion as a legal practitioner. How do we balance the two such that there is no conflict that arises between an employer and an employee regarding IP?
I think there's the accounting aspect, which will leave for accountants. I have my own views on that, but how can I put it? Employer-employee relationship. It is best, I would advise, and I would draft an employment agreement this way, that you negotiate upfront. There are people, like you highlighted, who are paid to invent. Let me use those as an example. These are guys who come every day to innovate. Their contribution to the company is not the same as Makate, who was in the accounting department. So those are a special breed of employee. So part of the negotiation, and you will find that in the long term, you will end up negotiating a lower price, because Vodacom made a mistake. If you imagine at the time the case started, if they'd given Makate 100 million, I think you would have walked away. So as an employer, you need to be a little bit clever about how you negotiate the revenue share or the profit share, as it were. But generally, speaking on the side of employers, anything, and this is a general principle, obviously you can negotiate your own contract. Anything during the course and scope of your employment belongs to your employer, generally. I've heard of cases where people have been fired for pushing their own businesses using company property. For instance, your laptop, for instance. So we need to carefully consider those things from that employer perspective. The other one, the accounting one, the value. I think you said something about value of IP. But the share is either a profit share or a revenue share. Each have different implications. Profit means the company actually has to make a profit. Otherwise, you won't make any money as the inventor. So also when you negotiate, understand the difference between profit and revenue. Revenue, we most of the time call it eating from the top or the top line, like you say. So these are little things that you should also, we must also educate ourselves about. I think another aspect of your question was the awareness aspect. I think generally in Botswana, we are at an awareness stage. There still needs to be a lot of interventions to bring us to a higher level of understanding of intellectual property, particularly as we get into the fourth industrial revolution and this whole mindset thing change. We need to equip ourselves because technology moves very fast. If you don't raise awareness levels, we're just going to be left behind, and that's a fact. I know people who are scared of using WhatsApp, but imagine how long we've moved from the time WhatsApp was launched.
No, thank you very much. Perhaps my final submission would be a comment to say that in this digital age where on average, we are creating content consciously or unconsciously as people. We are TikToking, we are on Instagram, we are on etc. And when we upload those things, there's always terms and conditions on these platforms regarding your IP. Are we possibly ceding our rights to our IP unknowingly because we're enjoying the platforms that have been created? And given that we are pushing towards developing our own apps, localized apps as citizens, as Africans, how do we then distinguish to say, okay, if, for example, I go viral on, say, Pause podcast here, and I feel that whatever revenue is generating from it, because I'm part of the content, what do we do? So perhaps it's to consider that we are generating a lot of content unknowingly with our WhatsApp statuses, and someone grabs your video and makes a meme out of it, and who knows where it goes. So just some guidance regarding that. What should we be looking out for? Or are we unwittingly seeding our IP, thinking we're having a good time and then maybe missing out on potential revenue down the line?
Well, I think we are missing a lot of things because, like I said, we're at an awareness stage. And I think that's a challenge when, like our president keeps on saying, building a knowledge-based economy. Part of that knowledge is knowing your rights. And that's why we have other legislation like Data Protection Act and so on. I don't want to stray from the topic of the day, but the reason I'm stressing it is that when people process your data, they have to get your consent. And when the act becomes fully operational, that will help to protect us. But the short answer to you is that we must either you register your IP, or you try and protect yourself commercially. Now, in this digital age, how are you going to make someone who's reading or looking at your viral content in Australia? These are some of the challenges that we need to educate ourselves on. Perhaps websites might have a click-through type of contract. That's the easiest example I can think of. If you have a website for your products, your services, or your content, then make sure there's a click-through by downloading or upload, whatever the term is, downloading this content. I am agreeing that I will not commercially utilize this content without your consent.
Thank you, Mr. Chilume, for blessing us with your presence. Lena Umpo for bringing him here. My question, two questions are from what he was saying. It's not related that much. I was asking I've noticed that some people here have maybe been through it, where you have an innovation or something that you want to present maybe to government, and then it needs to be tendered. Present something to government, it's not necessarily going to be yours. It's going to need to be tendered out. Why? Why is that the case? And then the second question, or observation.
Sorry, just one clarity. It's going to be tendered, meaning how?
We have to take it out.
Oh, okay. Should I answer it now? Is that the end of the first question?
End of the first question.
I need to answer it now because the result of getting old. Yes, we have those issues. Unfortunately, capitalism is a power relationship. And when I believe you're talking about taking an unsolicited proposal to government. I have one idea how I rata, but we have to, in terms of our procurement procedures, we have to take it out to the public. Again, it goes back to the question, if you give them an NDA, to say precisely the question that you're asking, and you have a non-circumvention clause, you cannot use the whole or part of my proposal for tendering issues. They possibly won't sign it. Perhaps they won't even take your proposal. So then the question becomes, do I give people my IP without an NDA? Or do I say, no, if you don't sign an NDA, I'm walking out? Because we've got bills to pay. It's a serious question. Unfortunately, it's not a commercial or legal question. It's your own principles. What do you do? I used the example of banka. If they want your business plan, they should sign an NDA. But it's a power relationship, unfortunately.
So what the government short left go resolve more.
But you see also social issues like our awareness. We had Mr. Maz's question earlier. Expanding on awareness, we are at a stage where talking about IP, we still don't know the difference between a trademark and a patent. Which one do you apply for? How relaying? What happens if SIPA rejects your application to register your IP? What is option 2? What is option 3? So we are not even at that level. So I mean, the government has a lot of work to do, and also the private sector, of course. We have a lot to do to raise that awareness to a level where we can properly protect our IP.
For my last question, corporate, an individual corporate, take the NDA, make them sign everything, and then what? Okay, come present. And then after the presentation, how do you safeguard yourself from such? Like what? How do you safeguard yourself? How do you prove, if there is anything to prove? You guys just.
I mean, there are people who will always take chances, and that's allowed. That's business. Point number one. The other point I would highlight is that an idea is nothing without execution. So that brilliant idea, you may share it with somebody, even with an NDA, and execute before you, or better than you. Are you still going to fight for that IP? What did they steal, really, at the end of the day? Really, when you think about it, what did they steal? You want to go to court with that? You see, so it's that next step. In other words, you're building your own case. If you move from a mere idea to a business plan, then you add figures, in other words, projections or forecasts. Then you do proof of concept. So you can't just sit on an idea, well, that's my idea. I invented it 2001. But it's 2023, you haven't done anything.
I mean, having taken all those steps, proof of concept, a prototype, thing, and then you go and present it. Everything is presented about. It's on the pipeline. How do you prove what I know about? No, you guys are far from this.
Then let's assume you're at proof of concept stage. Show me your proof of concept. Then I'll show you mine. You see, most cases it's not a legal issue. Most cases people are bluffing. Remember that you're negotiating. So if you say, I was almost there, what is he doing? In effect, they're negotiating downwards. In other words, they're saying, this thing is not rocket science. You see what I mean? So that drives down the value of whatever you're going to pitch.
Oh, thank you. My name is Titus. I'm the inventor of a board game. It's called Motswedi. So, had I knew, I would have cancelled my meeting because it was just about a violation of intellectual property. I would have came here earlier. So I was meeting the IP expert and the lawyer as well. So, but the question remains, when someone uses your trademark and the product that you trademarked for increasing sales or for motivating sales, because that thing is a crowd puller. But in the process, there's someone who is in between, who doesn't get enough of what revenue is generated there. Who is at fault? Is it the person who directly had the financial interest, or the go-between who said, I can organize a games night with this board game? Is the current thing, it gets people all together in one place. They will buy from your thing once they are gathered here. So now the question remains, who is at fault here?
Maybe I don't understand your question. You are the owner of the IP, I get it.
Yes.
Somebody is marketing
Yes.
it for you.
No.
Eh.
They're not even marketing for me. They just bought it for household use, like everyone else does buy it. It's in the market. They take it to rent. And then they know when we advertise that come and play Motswedi here, then people are going to be gathered here. But they don't just come and play Motswedi. They were going to buy food and alcohol during their time in playing this thing. And even in the flyer or the advertising material, they say, well, come through and for a games night where Motswedi is shit. Clearly you won't miss anything out of Motswedi. It will be there. So now the thing is, the host says, well, yes, we never had kind of sales before, but it's not us. We have engaged this person to bring the people. So now who do you look at? And also, do you quantify the fact that someone has unduly benefited from your IP, or because you have suffered some kind of loss?
Two things. And unless that person is doing something illegal in terms of another law, once you sell it, it's a product. You can't, for instance, tell somebody who has bought a bottle of water that you can only drink it this way. You know what I mean? So that's the first aspect. Once a person has purchased it, they can use it any way they want. So that's number one. Number two is a second transaction, completely different from the actual sale and purchase. If you see somebody using your product, and there is, how can I call it? There's brand equity in your game, like serious brand equity. There's no harm as an entrepreneur to say, hey, you are making so much money using my game. Can we discuss? It's a hustle. But he doesn't have to, I wouldn't say in this instance that you have, he's unduly benefiting from IP that is not his. Or I cannot say that you have lost anything, because the product has been purchased from you and that leg of the transaction is over. How you wish to benefit from repeated use of your IP rights, your game in this instance, is between you and the restaurant. They may say, never. I bought it. Now it's mine. If I use it to promote my own business.
Thank you very much for the enlightening conversation. Mine is just a thought which occurred to me when you were answering his first question about protecting yourself with people who would say, oh, we were just about to do that. So I was wondering and looking at the landscape we are in, where there is no awareness and possibly there is no law that is in place to say I can actually rely on this law to protect myself. How binding and how possible is it to say if I'm going to submit my business plan to a financier or to an investor or to a corporate, to say I can include a clause just at the top of the page to say the moment you open this business plan, you are bound by this clause to say you can't disclose, you can't do whatever is going to infringe my rights or is going to, I don't know. So how binding is that? And is it a possibility that can work?
Well, I'm not sure but the right word to use, but what you're doing in essence is you are giving the conditions under which you'll release your content. When they click through or they open the document, they've accepted your, if they didn't want to accept the conditions under which you'll release your content, they wouldn't have clicked or opened it. So it's binding on them, those who open.
My name is Mpomotari. We're back here with Mr. Chilume, and we're discussing intellectual property. If you've watched up to this point, definitely give this video a like, comment below on your biggest takeaway, and share this video with one friend. That would be legendary. And if you're listening on Spotify, I salute you. Please give us a review over there. Mr. Chilume, now coming back to this Makate versus Vodacom case, this dragged on this is 2001. So this is 20 plus years now dragging. And this is because it will be happening in November. So it's way over 20 years. This case could have finished much earlier. What are the things that Matake? Now the disease has come to me now. What are the things that he could have done in terms of IP, the right way to set things up so that this wouldn't have taken too long, where it's just a straightforward thing? It went to judges. They requested for all documents of the Please Call Me case. There was just so much that was happening. Was there a way that he could have set up IP correctly? And what is that could have just shortened this case immediately?
I think we've touched on the awareness aspect.
Yes.
I think he wasn't aware of his rights. Perhaps at the time he was like, I just want a share of the money. That's it.
Yeah.
That's why I think had Vodacom given him an offer, they'd be paying far less than that. But generally, that innovation process, you invent something or you manufacture something that requires protection in terms of a trademark. In this case, it was an invention. So to increase the solidity of his rights, he could have applied for registration of the invention. Being a practitioner in this field, he probably would have failed with registration. But that's not a train smash. As I highlighted earlier, we have other ways of protecting IP that is not capable of registration. Because the requirements of our act are simple and straightforward. Because we are dealing with an invention, therefore one assumes it's either a patent or a design. Let's deal with a patent. It must be new. Firstly, obviously, it must be new. And then the law goes on to say it must involve an inventive step. What that means is that looking at the knowledge that is present in the market, it must be a significant jump from what is currently available. Not just an addition Or maybe the corner is not 90 degrees, it's curved, it's a circle. You know what I mean? It must be a significant thing. And then it must be capable of being commercialized. In the sense that most inventions provide a solution. That solution is where the possibility of commercialization arises from. So those are requirements. I don't know what Makate actually invented. He had a brilliant idea, no doubt. But certainly in our country, I can't speak for the laws of any other country. In our country, it wouldn't qualify as an invention. So what's the second step? Then NDA, because now you don't have the registration. Now you want to try and protect yourself as much as possible, contractually. And then have that clarity in his mind. Do I have that sentimental attachment to this IP? How do I want to do it? Do I want to participate? Do I just want a revenue share? Do I want to license it? Or do I want to sell it outright? So I think, in a nutshell, that's how he would have improved the strength of his ownership. And also, don't do oral agreements. Put everything in writing.
Don't do oral agreements, put everything in writing. Okay. So, I've heard, when I think I've heard artists talk about this, when their songs are played on radio and they don't get money for it. Is that IP infringement or is it not? If I create a song, I came up with this amazing song, I'm in the shower. I write it, I go master it, mix it, everything is done. I take out that song and then all of a sudden I'm hearing my song on radio. Is them playing it on radio not copyright, IP infringement?
No, most definitely. Copyright is IP.
Yes.
It's a different type of IP, but it's IP. The full name of the act is Copyright and Neighboring Rights Act. Neighboring rights is what you're referring to, rights like broadcasting.
Copyright and neighboring. So can we find this online?
Yeah, the act is there.
Okay.
Neighboring rights covers what you're doing. Broadcasting, remixing, reproduction, all those kind of things, where the copyright owner would expect to get some commercial return from. So I think that's why COSBOTS was put in place. Yes. I don't know how far their mandate extends and how effective they are. But yeah, that's the role of COSBOTS as a regulator of that aspect of IP.
Okay, what about what we're doing here? Maybe having a podcast like this, and then we on another platform. Is that's also part of it?
Yeah, that's definitely a copyright infringement.
Okay.
Copyright is copyright is a little bit easier than the other forms of IP.
Yeah.
Because you own it by just mere creation. You don't have to rush to SEPA to register it or whatever. But in terms of copyright, you can license it. You can set a fee if you want to reproduce my thing or if you want to broadcast it. A fee is definitely negotiable under those circumstances.
Right.
The whole thing about IP generally is for people not to benefit of your IP. So it's really
from your creation. Basically something you make.
Yeah. And you'll see why IP as a broad subject drives innovation. Why would you invent something if you're not going to benefit commercially?
Right.
So that's the link from that perspective.
Right. So I'm also tempted to ask this question in relation to Makate. What are those laws or regulations? Maybe you have actually touched on it. But what are some of those laws and regulations he could have benefited from?
Well, like I say, I think I've touched on it a little bit. It's because it's an invention. It would most possibly be. It's definitely not a design. It will definitely be a patent. And as I've highlighted, I don't think it's capable of being registered. So his best bet would have been it was an oral contract. So to answer you, his best bet would have been to have an NDA. I'm also doubting how much work he actually did over and above having this brilliant idea.
Yeah. I think it was just an issue of something that he was going through. He needed that. He came up with the idea because of that long distance relationship with his girlfriend. Now, how could a written agreement then, how could a written agreement or formal IP registration process in terms of, because we have, this is my question. We have it in Botswana where we're told, I don't really want to say the regulator's name, but they're saying, come and do it. You can do it here. And, these things then come up later on where you now need a lawyer to come and help you out and solve these problems. But that's saying you can come and do it. You can come and trademark your things. You can come and do these things. I want your thoughts on that and how we should be thinking about it as business owners, as creators, as employees.
I see what you're trying to do there. I'm not falling for it. Government has, through its own wisdom, and I partly agree with them, they've made it easier for people to come and protect their own IP. But it's a highly specialized field, depending on what you want to protect through our existing laws. So I question the wisdom of helping people register their IP over the counter. But I would advise government then to upskill the people at that regulator.
Yeah.
So that they give the right advice. Because an important aspect of, let's take trademarks, is the classification of your IP.
Yeah.
Are you making clothing? Maybe it's class 25. Are you doing marketing activities? Another class. And the list of the classifications, it gives you, how can I call it, a heading. Like say, the one I remember off the top of my head is obviously class 25 for clothing, headgear, and footwear. Happy it's easy because it's just those 3 words. So is that a full protection of anything following that? What type of clothing? You see now when you get to the sub-levels, what type of clothing? Are you protecting T-shirts, caps? What else? Socks? And so on. Shoes, footwear. Are you protecting tackies or formal wear? Made from what? You know what I mean? So I mean, without...
Yeah. So what you're saying, if I protected, say, some of those, and somebody's wearing my brand, and they're wearing like sweatpants, and they have my brand over there, I'm left in the dark.
Well, crowded you would have protected in other classes. But at a simple level, if you haven't specified T-shirts and sweatpants and any other clothing, normally it's from the cap right down to in terms of branding, right down to the footwear. But if you say clothing, one can argue that it covers all forms of clothing. But does it? Yeah. So I mean, it's... I don't want to glamorize IP, but it's specific, like in any other trade or profession. There are guys who just know how to do a proper application for you. But again, I stress, I'm not, I see where government is coming from, particularly when you look at SMMEs and startups. The last thing they can afford is specialized advice. Perhaps government would be better subsidizing the specialized advice that startups can afford, or use the two solutions at the same time.
So this is the next question I have. It's interesting. We know certain. I mean, as a Botswana, I'm going to be very vague because I don't like to, but we know certain shops that sell counterfeits. How is they, but they're still in business. Every day we buy from them. I hope you guys know what I'm talking about. Yes? Yes. We buy from them on a daily basis, but these are counterfeits of true brands and stuff. How are they able to continue survive like that while they're selling counterfeits like that? Isn't there a strong IP stronghold?
It's there's an IP aspect to my answer, but then there's also border control and customs. I won't touch that one, because then the question is, how do they get in the first place?
Yeah.
For them to be an option.
Yeah.
You see very strange people wearing Louis Vuitton, for instance. When you know, when you know they can't afford it, a typical Louis Vuitton bag is what, 40,000
US dollars actually.
25.
Yeah.
You will get no. You ladies will know. You'll get no Louis Vuitton thing for less than 25,000, for sure. But
Chanel.
but they're here, and people want that. I once posted on Facebook. It was ill-advised, and I said, "Well, there's a big sale at Louis Vuitton because of." I mean, you can go to the station and you'll find those bags. Botswana want that. Obviously, there's a market for it, and they bit my head off. Yeah, so what? Type of response, but it's there. But I think on a more positive note, what I can highlight is that occasionally you will get Nike coming to Africa, who take about and close down shops. It's also, what I'm trying to highlight there is that also the owner of the IP must protect his IP themselves. Forget, laws don't matter that much, but they're there. But if you don't come after your own, protect your IP, because Nike is a good example, because obviously it's got a worldwide registration of its logo. So they are well within their rights to come here and come and protect. You can't stop this movement, if I can call it a movement, because the market demand is there.
Yeah, I think that when it's like that, it's pretty interesting also, just how it plays out. But IP is so, you have to really get it and understand it, or else you're really missing, and you can miss a lot of money. You can leave a lot of money on the table also. I wanted to talk about brand equity, and how, first of all, do we measure brand equity in the lens of IP? How then can you understand that, okay, this brand is worth this much because of the IP? Yeah.
Let's take, I hope you're all aware of the Botswana Stock Exchange and what it means as a stock exchange, and how they calculate market capitalization. One of my favorite examples of brand equity is Apple.
Yeah.
the company. In dollar terms, it is 21 times bigger than our entire stock exchange. If you want evidence of market brand equity, there's no better example
3
than
trillion.
that. The entire stock exchange, one company. It's just a phone. Again, all phones perform the same tasks: WhatsApp, call, voice, text. You can camera. Why do you choose Apple over Tech? Is it called Techno? I have nothing against Techno. I'm just using an example of a different brand. But yeah, what are you paying for, essentially, when Techno does the same job?
The brand.
Yeah, that's the equity. And when you look at corporates as well, on a more high level, from a more high level perspective, you will go, let's say you're a subsidiary of a holding company. I guess the subsidiary trade. The holding company, it just holds the shares in the subsidiary. Banker will tell you, we want a holding company guarantee, parent company guarantee. But what's in there? Where's the value in the holding company? What revenue is it generating? Nothing. So you'll find, again, it's brand equity. You can revalue your goodwill and IP on an annual basis, depending on the type of business you run. So one of the suggestions we make to our clients is that let the IP reside in the holding company. In other words, how I now let's subsidiary of invent an Apple phone. The IP, to redistribute the value in a group of companies, it's better you hold your holding company. When you go to the bank, then you actually have value that you can revalue on an annual basis if you want. So your guarantee actually means something. There's value in it.
Oof. And then there's also just goodwill. That is, how do we value goodwill? Because it's also part of that. How then do we value goodwill? Is what's the metric?
Well, like I highlighted earlier, again, I don't want to speak for accountants, but it has an applicable accounting standard, high value and thing. And then again, I made the point that it's valued on disposal, not when you hold it. There's the little nuances that the accountant they had.
So, in terms of IP, then where are we seeing?
But as an accounting entry, you can revalue and add to that value. You gotta give value in theory, because if you don't sell it, if you get what I'm saying.
Where are we seeing IP going in the future? What are we seeing about IP? What are the changes that we're seeing as IP is going and unfolding? Where is IP going in the future, essentially?
I think, again, we will always be talking about the stage we are in Botswana at an awareness level, which is, it is imperative for us to, and I'm including everybody, individuals, companies, regulatory authorities. We just need each of us to get that awareness level much higher. Point number 2, from a legal perspective, and I think I touched on it earlier, once an innovator or an inventor feels the idea is protected, it is going to drive innovation up.
Yes.
The higher innovation goes, the higher the value of the IP goes. And then we also have to tackle the protection from a commercialization aspect. We're going to see again a significant rise in those kind of things. So it's a genuine economic driver. I've just given an example here, Apple and the size of that. So that's the direct link. The link, in as far as the growth of the economy is concerned, is between your rights and your ability to commercialize them. And if you look at it that way, it's going to explode. I don't know how our fourth industrial revolution is going to turn out, but we will see. But bottom line is the link between the rights and commercialization. Once we get that, then innovation shoots through the roof.
Once we get that, innovation shoots through the roof. What are some of the, I'm sure you just gave them actually just now, but I wanted you to just leave us with some of your best tips. I'm an employee, I'm an employer, I'm a creator, I'm an artist. What am I thinking about leaving this conversation in terms of IP?
Sorry, in what sense?
Just your takes, your last hot takes, as in like your biggest advice right now to all of us.
Yeah,
you could take us all, or you could take us.
Yeah, I think we are not. I don't want to say Africans or whatever, because I'm patriotic, but we need to read more. We need to. We need to empower ourselves.
Yeah.
We really have no excuse for not empowering ourselves knowledge-wise. And I think that's where I must give credit to our president for emphasizing a knowledge economy. You really have no excuse. Let me take the last phrase, brand equity. You've got Google right next to you. 5 minutes later, you're a master. You know that mentality. Let's do that. And you know, I've spoken about the link between your rights, protecting your rights, and the commercialization aspect, and as a driver of innovation and ultimately the economy. I've spoken about this commercialization is very important, because if you are lucky and you break into the global stage, maybe you could be the next Apple, the next Coke. Do I even need to talk about Elon Musk? I didn't know about him 10 years ago. He's now the richest man in the world. Why? Innovation, IP rights. He knows he's protected. That's why the value of his investments have grown to such a unimaginable stage. I don't think one man should have so much money. beyond a billion.
Yeah.
Really? But yeah.
Yeah. Yeah, he's definitely competing with countries, not individuals.
Yeah, he's at a stage where he can actually influence governments. One man, not even a company, just one man influencing countries.
Yeah.
Here's the value of what's this company called again?
Tesla, SpaceX.
Okay, the value of his investment, it was measured about a year ago. It's more than, and I stand to be corrected, more than the GDP. They compared it with South Africa.
Yeah.
His home country is more than the GDP of South Africa. One man. But that's the explosive, what we can learn from that is the explosive power of innovation. He's just launched a phone. What do you think is going to happen to Apple?
Food for thought, food for thought. Yeah, thank you so much for joining us, guys. If you've watched this episode up to this point, please give it a like, comment below, share your thoughts. Let us interact. We read all your comments. Make sure to check out AJA. Thank you. Big thank you to them for sponsoring and leading this session. The links will be below so that you can get in touch with them and learn and understand everything about IP. But without further ado, ladies and gentlemen, we'll meet same time, same place next time. Be great. Thank you guys for watching this episode. We really hope you enjoyed it and learned something new. Deep Dive is dedicated to bringing you the most comprehensive and engaging information about business, personal finance, and personal development. Make sure to hit that subscribe button to stay updated with all our latest content. If you like this video, give it a like to show your support and help us reach a wider audience. And don't forget to share this video with your friends and your family who may be interested. Sharing helps us grow our community and connect with like-minded individuals. Leave a comment below and give us your biggest takeaway on this episode. If you're interested in being a part of our live studio audiences, make sure to register for the next show. Can't make it to the show? No problem. Check out our Patreon page to watch the full episode and get exclusive access to more great content. Thank you for watching, and I'll see you in the next episode of The Deep Dive.